Welcome to our fifth lecture on Module 4. We're continuing to discuss the timeline and we're going to continue to talk about the progress through that process. Right now we're on the bullet that is about implementing the hiring decision. Let me just backtrack so we can see how this fits into the big picture of things. Here. So as you know, in our first lecture, we talked about the recruitment process. And our second, we talked about the testing. I think the second and third, we talked about the testing process that's also usually pre-employment. And now we are talking about the hiring process. And we got through about half of the implementing decision part. And in this lecture, which will probably be our last on this module, we're going to complete the hiring process, and then we're going to talk very briefly about performance appraisals and disciplinary process generally, and also very briefly about the termination. So let's return to our implementing the employment decision. As you know, we've talked about the background checks and negligent hiring issue. Now we're going to talk about criminal records, which is also oftentimes part of that background check process. So if we aren't doing criminal background checks on employees who are in positions that are customer facing or that involve access to customer data, your client is exposing itself to potential negligent hiring charges. And so it's a good idea to consider whether it makes sense to roll out a criminal background check process under those, given that fact. You always want to make a distinction between arrest records and conviction records. Obviously, an arrest only means that that person was detained for some period of time. It doesn't mean they were ever even charged with a crime, and certainly doesn't mean that they were convicted. As a general rule, you should not a client should not consider arrests, should only consider convictions. Another relevant thing is to make distinctions between misdemeanors and felonies. Obviously, the felonies are the more serious crimes. Doesn't mean that misdemeanors are always not serious crimes. They can be serious crimes. But as you are making the decision, it's helpful to be rather granular. You don't want to have a rule that says anybody who's ever been convicted of a crime is not going to be hired. If you use that kind of logic, then you wouldn't hire somebody who has a speeding ticket or who failed to yield at a stop sign or something along those lines. Criminal records in the United States are very decentralized. It is almost impossible to absolutely confirm a person's criminal record. For example, I may live my entire life in Collin County, but I may have taken a vacation trip to Hawaii, and while I was there, I might have been charged with a misdemeanor. Well, that criminal record isn't going to show in Collin County. It's going to show in whatever county I was in Hawaii. And since I've never lived in Hawaii, I've never worked in Hawaii, a criminal background service that is doing this review of me, to confirm my criminal background, would have no reason to check databases in Hawaii. And each one of those databases costs money. And so it would be wildly expensive and administratively almost impossible to do all the counties in the United States type system. I'm not even sure that all the counties in the United States have all of their records online so that they are accessible in that manner. So what typically companies who run these businesses do is they look to see where this particular person has lived and has worked for income reporting purposes, and then for maybe the last 7 years, because usually you look back 7 years. Maybe they might look back 10 years for this purpose, and then get those particular counties, and sometimes they may look at adjacent counties. So it's not every single county in every single state. That would be crazy expensive to do. So it's hard to find, and it's logistically very, very difficult for an individual to do. there are businesses that know how to do this efficiently and quickly. And so most clients who choose to do background checks on their employees are going to use those services. Obviously, if there is an indication based upon the information that you've received that the candidate might be unfit and might be somebody somewhat likely to cause someone else some harm, either financial or physical, then obviously the decision ought to be not to hire that person. But you don't want to, while you obviously want to keep your workplace safe, you don't want to err on the side of cutting everybody out who has some kind of bad record. As we've discussed previously, African Americans and Latinos are more likely to be arrested and are more likely to be convicted of crimes than white individuals are. So if you have a policy that says anybody who's ever been convicted of a felony, or even over the last 7 years, that person is going to be ineligible for employment, you're going to be excluding a lot of African American and Latinos, and that is definitely going to have a disparate impact. The EOC is very well aware of this fact, and so its policy is that there needs to be an individualized analysis. You need to consider what are the safety risks with the particular job that you're hiring for, and do the particular aspects of the crime that this person was convicted of, do they connect with that particular risk factor? So for example, the DWI situation, driving while intoxicated, if the person doesn't need to drive as part of his or her work, then why would you care that they have DWIs? Maybe they're going to walk to work, maybe they're going to take the bus, maybe they're going to have some family member drive them to work. Plus, even if they were to drive intoxicated to work, the employer isn't going to be responsible for that. That's that person's own choice. So you need to be careful that you are making that kind of individualized assessment. On the other hand, you don't want it to become this subjective system where you decide in one case, well, DWI is important. In the next case, well, DWI isn't important. You want to make sure that within that individualized analysis, there's a lot of consistency, and there isn't the potential for somebody who sees a name, for example, that they may assume the bearer of that name is African American, or the bearer of that name is Latino. You don't want that person, then maybe that person might be more likely to say, well, this is a serious crime. But if the person had a name that was more likely to be Caucasian, maybe that person would, not even intentionally, but just because of an implicit bias, might be more likely to think, well, that's not relevant. One way to address that issue is to have a matrix where you have your positions, your categories of positions, and then you have a variety of potential crimes. And so, for example, if the person has access to credit card information, let's say it's a cashier or a waiter or a bartender or something like that, then you'd be interested in what was this person any kind of fraud or financial crimes, because they might use that credit card information to steal from the customer, for example. If the person has a customer-facing position, especially one where there might be opportunities for tensions to develop, or where they and the customer might be apart from other folks, you need to look for violent crimes. Did this person have an assault background, murder, rape, those types of issues? And so you want to be granular in how you approach that. Obviously, if the job involves driving, you would be interested in looking for DWI type of crimes. And so you have this matrix, and then the service that you use would be able to apply that matrix to each case. And so every single candidate, whatever that person's candidate's race is, national origin, or gender, would be treated the same way under that matrix. And companies will give you, the companies who have these types of programs will give you recommended settings for those matrices, I guess, that you may want to consider. Let's talk about credit reports. Credit reports, well, actually, the Fair Credit Reporting Act also is the statute that relates to criminal background checks. So the Fair Credit Reporting Act, for FCRA, is the major federal law that regulates the gathering, sharing, and use of information by employers and consumer reporting agencies. Now, for the most part, FCRA does not tell, number one, FCRA does not generate, its focus isn't on the employment relationship. FCRA is primarily about just credit reporting services and what the things are that they must do. It applies in the employment context when an employer is doing some kind of background check on a current or prospective employee, but that's not the major focus of this particular statute. So if you don't already have a Quizlet for FCRA, you will want to add that to your list. FCRA really isn't designed to tell employers what they can consider and what they can't consider. It's more about the process, what the steps are that the employer must follow. There are two important, well, there's also important terms, but there's two that I wanted to bring special attention to. These are terms that are defined in FCRA, and the first is a consumer credit report. And this is something that one of those consumer reporting agencies, it could be the criminal background check company that you're using, or it could be another credit reporting agency, Experian, something along those lines. Anyway, that report that it prepares that lets you know about, credit worthiness, character, reputation, criminal background checks, whatever the thing is. This would be a report based upon scanning records, such as how timely you've been paying your mortgage, that type of thing. Investigative reports are when there's actually personal interviews. So it's not just pulling up the data chain, but it's actually talking with individuals, co-workers, neighbors, friends, those types of things. Obviously, this is by far the more common category, the more important category for our purposes. Probably you know this already, but if you don't, credit reports are riddled with errors. I'll relate to you a personal situation. My father, when I was a high schooler, we lived in Far North Dallas, and his name was not a very common name. But there is another person who lived in Far North Dallas at the time who had exactly the same name, including the same middle initial. My father was very proud of his record of timely paying all of his bills, but his doppelganger was not quite so consistent and had a very poor credit rating. Anyway, something came up. I don't know if my parents were refinancing their mortgage or what. Anyway, it came up that my father had all of these unpaid bills, and in fact, he didn't. But it was only because of this refinance or whatever it was that he became aware of this. He was able to rectify the problem, but it certainly educated us that those reports can contain lots of errors. It could be somebody with the same name or similar name. It could be somebody who has a similar social security number. Lots of different errors or ways that those can happen. So it's a good idea for periodically to check the credit report. And as a result of the fact that these oftentimes have errors, it's very possible that when an employer, potential employer, does a background check, that it will find out information that isn't true at all. And so because of this fact, FCRA is designed to give either the prospective employee or the employee an opportunity to rebut or respond to the credit report. And so as part of that process, the employer has to let the applicant know that a credit report will be obtained, and the applicant has to agree to it. And the agreement to agree to submit to this can't be part of the employment application. Now, as a practical matter, it's usually like for the next document or the next electronic document. So probably from the perspective of the applicant, it feels like it was part of the employment application. Typically, if you have an electronic application, you're not going to allow the process to be complete if you're going to go ahead and use this credit report option, unless the applicant also signs the agreement to allow for the credit report. If the employer is thinking that it will have an adverse action, such as decision not to hire, to fire, to demote, not to promote, the employer needs to also include that in the statement. And as you can see, why would you do a credit report? Why would the employer spend the money unless it was going to impact the employment decision? So almost always that statement is going to include language that indicates that the employer may take adverse action. And obviously it's going to be a standardized boilerplate type language, so we won't tailor it to the particular employee or just say, but probably describe the categories of adverse action that might be taken. Generally speaking, let's fast forward. So let's say that the applicant completes the application, then completes the second document. The credit report or the criminal background report is done. It reveals some negative things. And so then the credit reporting agency, whichever one it is, will send to the applicant, I guess, a copy of his or her report. And then he can see it and decide whether it's accurate or not. If he says it's inaccurate, then he can go back to the credit reporting agency and say, hey, wait a second, that's not me. That must be somebody else with my same name. And the credit agency will research it. And if they agree that, in fact, this applicant isn't the same person for whom they returned the data, then they will clean up that person's records. You might think to yourself, well, then that means once the record is cleared up, that the employer will now hire that candidate. Usually that's not the way it works, because the process of doing that background check and having all of that research typically takes many days and sometimes weeks to get all that resolved. And so in the interim, the employer has gone ahead and hired somebody else. So really the applicant is not directly helped by clearing up the record this time, but he may be helped for future times. And there is no obligation that the employer has to leave the position open until the employee has an opportunity to respond and to clear kind of his quote unquote reputation. Now, when the employer denies employment because of one of these criminal background checks, that information does need to be provided to the employee. Otherwise, the employee won't know that there's something in his or her report that needs to be cleaned up potentially. Generally, and so this is a legal requirement, so the employer has to do it, obviously. But generally, it's not a good idea to tell potential employees why they were not hired. It's good to just leave something diplomatic and rather vague. Thank you for your candidacy. We have filled the position with another candidate. We appreciate your interest in the company and wish you every success in your future endeavors, that type of thing. Or you don't even have to say that the position was filled by somebody else. You can just say thank you for your interest. At this time, we do not plan to go forward with your candidacy. We wish you every success in your future endeavors. Please, we encourage you to apply for future open positions, something along those lines. It's so while you do have to reveal the reason why the person was rejected when it has to do with a criminal background check, in other cases, it's not a good idea because obviously it's going to raise more questions, and that's one reason you don't want to do it. So if you say, we didn't hire you because your education wasn't as impressive as the other candidate, well, then very likely they'll call you up and say, well, where did that person go to school? What did that person do? It invites additional questions. So that's one reason you don't want to do it. The other reason you don't want to do it is that sometimes those information will not be 100% accurate. Perhaps the objective reason you have is that the candidate that you rejected, his or her educational background wasn't as impressive as the person whom you ultimately went with. But It may also have been that he wasn't very the candidate you rejected wasn't as impressive of an interview as the one you selected. But many times when people are writing a letter, they don't want to insult somebody saying you were a bad interviewee. They want to stick with kind of objective, non-hurtful facts like your educational credentials were not as good a fit or something along those lines. But then when you give a partial answer and then the person sues, and people look and go, well, gosh, his education is about the same as the other guys. And so then it starts looking like maybe there was a discriminatory motive. And you've already locked yourself in a written document to one reason, when in fact, very possibly the reason was quite a bit more subtle and complicated than your letter could provide. Now, sometimes people say, but wouldn't it be nice to that person to let them know how they were off base so maybe they could make some improvements? Possibly that would be a nice thing, but at the end of the day, the hirer isn't there to be nice to the candidate. He's there to advance the interests of his employer. And the employer's interests are best advanced by a polite but vague answer when the candidate is not a successful candidate for the position. Okay, we talked about the pre-adverse action disclosure and the adverse action notice. So we talked about that. Let's see, Texas does not limit the use of credit reports. We already talked about how the EOC and the EOC's interest in this is not restricted to the criminal background, but also the credit report situation. Oftentimes, minority families, because of the fact that many times they have a lower net worth and a lower income, are more likely to have credit issues. And so therefore, are more likely to have some credit problems on their credit report. If that is a tool used to decide who to hire, then that will likely have a disparate impact on the hireability of minorities. So let's talk about references. So there's a variety of, I guess there's two ways to look at references. One is you, the employer, want to get information as you are interviewing candidates for a job. And one of those, a very good source of information potentially is going to be contacting the candidates' previous employers. In theory, that should be a good way of getting information, and sometimes it genuinely is. But oftentimes it's not. And the reason that it's not is that most sophisticated employers will not give meaningful references. Now, there are some exceptions to this. For example, if Bob was employed by Exxon and his boss at Exxon has now left Exxon and retired or gone to work for another company, and Bob is using that former boss as a reference, well, that former boss is now no longer having to operate under Exxon's rules. And so that former boss could give, if he wanted to, could give a detailed and candid reference. And so there are times like that where it is useful. Smaller companies oftentimes don't have official policies about when they give detailed references or not. And so sometimes a mom and pop organization will be more likely to give a complete reference. So you sometimes can get meaningful references, but more often when the employer is a large corporation, is you're going to get what I refer to as name, rank, and serial number type information. You'll get dates of employment, last position held. If it's somebody applying, say, for a mortgage, you might be able to get some pay information, things along those lines. And sometimes you can get whether this person is eligible for rehire. So that would be the type of information that can help you confirm that this person is not making up big parts of their performance background or the performance history or the resume history. But it doesn't really let you know how they were performing in that job. So it has some utility, but not a lot of utility. So why do employers not share more information? And again, it goes back to the risks. Once the employee has left the employ of the place who is going to provide the reference, there really isn't a lot of upside for that ex-employer to provide a detailed reference. I mean, how does it help that employer? There's only downsides associated with it. Let me explain what I mean. Let's say that the employee wasn't very good. So you say, I don't think I'd hire Bob again. Bob, he came to work late pretty often. I thought I smelled alcohol in his breath a couple times. And he could be pretty unpleasant at times, pretty surly, and missed several deadlines. So no, I wouldn't recommend him. So at that point, obviously the employer who was considering Bob for a position is unlikely to hire Bob. Bob hears, and maybe somebody at the place where he's applying tells Bob, well, Bob, the reason that we didn't hire you is because of the reference that your last employer gave. Well, Bob then might sue the employer for, let's say Bob is a member of a protected category. Well, the only reason they said those things about me was because they don't like African Americans or people of Polish descent, or Rastafarians, or whatever the particular group is that Bob might be a member of. So the former employer could face a race claim on that basis. Or it could be that Bob is saying, you defamed me. You said I was late to work all the time. Well, I was only late to work 20% of the time. All the time means 100% of the time. But 20% is substantially lower than all the time. So you lied. You engaged in defamation. And so you can see how words can be misconstrued or misinterpreted. And so there are downsides to giving negative references. But there's also downsides to giving positive references. Let's assume that Bob was as much trouble as I suggested, but the employer gave only really good, oh, Bob was great, we were so sorry to see him go, such a hard worker, always positive, never late to work. And then he's hired by that company, and it ends up that he was hired to do deliveries, and he while he's driving a company vehicle, intoxicated, he kills a family. And so it comes to light that his last employer, had called, and if only the employer before had said, yeah, Bob would come to work smelling of booze pretty often, then the employer that hired him probably wouldn't have hired him for a driving type job. And if he hadn't been hired, then he wouldn't have been in the company van, and he wouldn't be on the clock driving in that particular location, and that family wouldn't have been killed. So guess who that family sues? They sue, or the survivors at least sue, the former employer who gave the positive but inaccurate reference. Sometimes when you get the reference call, and I've certainly seen this a lot, because sometimes will be a reference check for former colleagues of mine. It may have been several years since I've talked with that person, and it's possible, especially if I had lots of people who reported to me, that I may confuse some folks, especially if I'm getting the call out of the blue without a context. So if somebody calls me and says, tell me what I see that Sally Smith used to work for you. She's listed you as her former supervisor. Tell us what you know about Sally Smith. Well, I get Sally Smith confused with Susan Smith. Sally Smith was a great employee. Susan Smith was not a great employee. But I haven't really thought about it in several years. I haven't seen either one of them in several years. And for whatever reason, my brain thinks about Susan. And my evaluation is accurate with respect to Susan, but it's not accurate with respect to Sally. I may have in the last 10 years might have had, 200 people who reported to me. And so you can see that there's a lot of risks associated with these types of evaluations. So for those reasons, employers usually are not willing to give those. Let's talk about the compelled self-publication risk. I've talked about this, I think, a little bit earlier when we talked about the Vermont case briefly. This is not too much of a risk here in Texas, but if you are representing a multi-state employer, then you ought to be aware of the fact that sometimes when an employer dismisses an employee for reason X, but the employee disputes the reason. He says, I didn't really steal, or I wasn't drunk at work, or I didn't have all those charges, or whatever the reason is. Still, when that employee goes to his next job interview, it's very likely that it's going to come up as a topic what the circumstances were that resulted in him leaving his last employment opportunity. And so when the potentially new employer says, well, why did your employer let you go? Obviously, the candidate has to, or should say the truth. Well, they fired me for theft, but I didn't do it. Well, what is the potential employer going to do? Believe the employee or the candidate here, or believe the employer that dismissed him? Obviously, very likely to believe the employer who dismissed him. And even if the potential employer doesn't believe the former employer, they're at least going to say, we don't want to take that risk, right? And so they're definitely not going to hire the person in those circumstances. So we call that compelled self-publication. Publication is a term in this context, not meaning like a book is published, but publication is having to share a defamatory statement. So the verbal expression of that statement is the publication. And here you are being forced to publicize the defamation about yourself, but you're compelled to do so because of the question that you've been asked. And some courts have said, under those circumstances, that the former employer is still guilty of defamation, even though the former employer never told anybody other than the employee the reason that the employee was being dismissed. But because they knew that the employee would have to relay that story to all future employers, that qualifies as compelled self-publication. This is not a very likely scenario to work in Texas, but there are some states that have accepted this logic, and so it is something to be aware of. So let's consider the scenario, see how it plays out. So Bob was fired for stealing. He says he didn't do it. He at an interview with another employer, asked him why he was terminated from his last job. Bob says, well, they said I stole, but I didn't. Obviously, that employer Food Lama doesn't hire Bob. Bob may have a cause of action against his former employer for defamation because he was forced to repeat the defamatory remarks to his prospective new employer. So after acquired evidence, we did talk about this previously, so I'm not going to spend time on this one in this lecture. If you haven't added this word to your Quizlet, though, go ahead and do this. It's important to note that after acquired evidence does not remove liability from the employer for any unlawful actions. It merely reduces damages. The damages end on the day that the employer gets the after acquired evidence. And so that's the key thing. So, I mean, it can be very significant in terms of damages, but it's not going to remove the guilt or innocence aspect of the trial. We've talked about defamation earlier too, so I'm not going to spend much time on it. If you don't have your definition in Quizlet, here it is again for you. It's always important to remember that if a statement is true, it can't be defamatory. Here we have the elements of defamation. Again, we see the definition of published, which just means communicated. There are two types of defamation. One is slander. The way to remember this is slander is spoken. They both start with an S. And libel is a lot of times remembered because by the term lasting letter. It's written usually. It doesn't have to be written. It can be something, a video posted on the internet that lasts, a spoken word that is not recorded, you know, is ephemeral. It's gone almost as soon as you say it. If it's recorded and posted somewhere, though, it's lasting. So a libel is any mechanism in which the statement is published that would last longer than just the time it takes to actually say that. So when an employer, let's say an employer does give a bad job reference, and so now there's the allegation that it was defamatory, what types of things can the employer say in response to respond to that? One is that the employee consented to the employer giving a reference. The employee didn't have to give that reference to a potential employer. So a lot of times a past employer might say, yes, I will give a reference, but you need to sign this release saying the type of information you want us to give. And many times this can be an automated procedure. I'm familiar with some companies that have an online reference system. Do you want us to share with potential employers your dates of employment? Do you want us to share your last title? Do you want us to share your last wage rate? Those types of things. Now, of course, the release is effective when it's, you know, kind of facts, objective facts. But if it's a more subjective view, then that's a little bit harder to say that the employee actually knew. Going back to the idea of positive references, let's assume that one of my best employees ever was Teresa, and she asked for a reference, and I say, sure, I'd be delighted to give you a reference, Teresa. You were so awesome employee. And so her potential new boss calls me up and says, hey, tell me about Teresa. And I sing her praises. I say, oh, she was so awesome, so positive, so wonderful, just you know, really, really exceptional. And the employer says, okay, well, that sounds amazing. I'm so happy to hear it. But, you know, none of us are perfect. But what would be the one thing that you wish Teresa had done differently? And I say, gosh, I can't even really think of anything. I mean, she was just so awesome. But if I had to say something, you know, her handwriting wasn't the neatest. Sometimes I'd get a note from her, and it would take me, you know, longer than you would think it would ordinarily take to be able to decipher it. But most of the time she'd type it up, and so, you know, it wasn't even an issue. But, you know, yeah, if I had to say one criticism, it'd be that. But that it was so minor, and she was such an awesome worker. Well, then the potential employer goes, well, thank you for telling me that, because I was going to hire Teresa to be a calligrapher, which is, handwriting imitations. Now that you're telling me she was bad handwriting, I'm definitely not going to hire her. So here, I thought I was giving the best reference ever, but what I said actually sank Teresa's opportunity to get the job. So even very, very good references can end up being not so good references. So if you decide, yes, I do want to give this person a reference, another good path to consider is to give a letter of reference. You may be asked to confirm the letter of reference because obviously they can be forged, and you might say, I'm willing to confirm the authenticity of the letter of reference, but my reference will be limited to the things that I actually say in the letter. That can be another approach, and that way you can kind of make sure you're wording it in a way that is only positive and is 100% accurate. Of course, the problem with a letter of reference is that it does involve a lot of work. And again, what is the return that I'm getting for doing all this work for Teresa? Another issue, and this is more kind of the legal professional mind, is when a legal professional sees a letter of reference, many times they think, this was part of the settlement, because it's very common as part of a settlement to give, say, a neutral letter of reference. And so many times when I see a letter of reference from a former employer, I assume there was some kind of dispute between the parties. So it actually makes me less likely to want to hire that person, not more likely to want to hire that person. Another way that an employer can get around defamation is qualified privilege, which we'll talk about in a second. But we've already talked about the fact that truth is a perfect defense. Even if it damages the person's reputation, if it's a truthful statement, it's a truthful statement. It can't be defamation. So let's talk about qualified privilege. This sounds really good, and I don't want to minimize it, but it's not as good as it sounds. It doesn't provide as much protection as maybe it initially will appear. So let's talk about the concept of qualified privilege before we drill down and talk about how it relates to employment context, because this idea is quite a bit larger than just employment. So qualified privilege to defamation exists when the person communicating a statement has a duty or legal permission to make the statement. Let me give you an example of a total privilege. If I am a congressperson and I am on the Congress floor in Washington, D.C., I can say anything I want to about anybody, and I cannot be charged. I cannot be civilly sued for defamation. I can say things that are outrageous and completely false, and I cannot be sued. I have a total privilege under those circumstances. But that's about the only time that there is a total privilege. Most of the time in life, we have what's called a qualified privilege if we have any kind of privilege at all. And what this is getting at is the idea of, well, you know, sometimes it's good to share information. Imagine for a second that I am the superintendent of a school district, and I have to dismiss one of my employees because he had some inappropriate interactions with the student. Maybe it was of a flirtatious nature, maybe it was some threats, maybe he hit a student or something along those lines. Then that former employee, that former teacher, applies to work for another school district. And that other school district calls up my school district and says, hey, you know, Bob or Sally has applied to work for us. He or she worked for your district for 3 years. What do you think about him or her? If I said, oh, I can't say anything, then Bob or Sally might engage in that same conduct at the next place of employment. We don't want that. We don't want, you know, school children to be exposed to dangerous circumstances. And so as a result, in certain situations, employers have a duty to reveal certain types of misconduct on the part of employees. So daycare centers, schools, places like that, and even other licensed entities like doctors and dentists and things like that have to report when they have employees who've engaged in some significant misconduct. And under those circumstances, there's a qualified privilege. Yes, they have to report it, but yes, they also have to be truthful. I mean, they can't make up a story. I mean, think for a second. Let's say I was a teacher at the school. I did nothing wrong. I decided to quit because I wanted to be a stay-at-home parent. 2 years later, I decided to apply to another school district. That school district calls my former school district, and the former school district makes up a story about me, saying that I did X, Y, Z when I didn't do X, Y, Z. Well, the qualified privilege wouldn't apply under those circumstances. I could sue them for defamation. So it's not a blank check. It doesn't permit the former employer to say anything. Texas does have a qualified privilege for former employers who are acting as reference checks. And so we'll look at that statute in just a second. But it's important to keep in mind that it is only a qualified privilege. It's not an absolute privilege. The privilege can be lost if the statement was made with malice. And again, this is a defined term. So put this on your Quizlet. Malice in its contents means intent to harm the person's reputation, or this is the more likely category, with reckless disregard for the truth or overly broad publication of the statements. So again, my name is, Susan Green, but Susan Green with an E at the end. But this school district had another teacher named Susan Green without an E at the end. And that Susan did X, Y, Z. Well, when they're pulling up the records in the personnel office, they pulled up the wrong record. Did anybody have any malice against me? No. But they probably did have a certain level of recklessness. I mean, shouldn't they have confirmed the spelling of the name, especially since it's such a common name? And so you could easily argue that the qualified privilege didn't attach because the person looking at the record just didn't pay enough attention to make sure they were talking about the right person. So again, unless you are in a situation where you are legally required to reveal the information, the best practice to not to just give name, rank, and serial number, not to give a substantive a reference. So here's the statute that does give that qualified privilege. So an employer who discloses information about a current and former employee is immune from civil liability unless it is proven by clear and convincing evidence. So let's pause here and talk about clear and convincing evidence. We talked about this earlier that we have the preponderance of evidence, which is just a 51% standard. And that's what we use in the vast majority of times in civil cases. And then we have in the criminal context, beyond a reasonable doubt, which you might say is more like a 99%, 96%, something like that, percent chance. And then kind of here in the middle, which is not used a lot, but is used both in the criminal context and the civil context occasionally, we have clear and convincing. And I like to think about this as being about a 75%. It's when the evidence is pretty clear, but not beyond a reasonable doubt clear. Anyway, so you have to have higher level, the plaintiff in this case would have to have a higher level of evidence than the usual preponderance of the evidence. I'm going to go ahead and erase this. So that's one of the benefits of this qualifying privilege statute in Texas gives. So it has to be by clear and convincing evidence that the information disclosed was known by the employer to be false at the time of disclosure, or that the disclosure was made with malice or reckless disregard for the truth or falsity of the information disclosed. So again, you can see if the person pulls up the wrong record, the employer knew at the time of disclosure the statement was false because they had the record that showed I had a spotless performance record. So again, in the real world, employers are aware of the fact that sometimes people do things carelessly and sometimes they reveal information in a way that isn't appropriate. And the employer doesn't want to be liable for that, so no reference is the better course of action. So let's discuss in verifying employment eligibility. We will talk more about this later on, but this is, again, part of that process, the new hire process, where you are confirming that the person is eligible to work in the United States at this time. So this, again, goes back to IRCA, the Immigration Reform and Control Act, and it really has two aspects to it, or at least two that we're going to be focusing on. One is that an employer can't hire people who are not eligible to work in the United States. And the goal of IRCA was to reduce the number of undocumented individuals, people who overstay their visa or who enter the country without the lawful documentation. The idea being many of those folks come to or stay in the United States in the hopes of gaining employment. But if they find they can't get a job because employers won't hire them, then they're likely not to go to that action to do that. And then the second part is that employers are prohibited from discriminating based upon national origin or citizenship. So this, you could say this one is kind of anti-immigration, and this one is kind of pro-immigration. But what we're going to focus on in this section is the I-9 requirements of IRCA. And this is the process by which this first part is enforced. I mean, how does an employer know whether his brand new employee is eligible to work in the United States? Well, all newly hired employees within 3 days are required to provide I-9 documentation to their employer. And this, there's lots of different documents that can be provided, but the document has to demonstrate that the the person is eligible to work in the United States and has to connect that eligibility through a picture to the person that the employer is seeing. So you can't have, for example, a birth certificate. Yeah, the birth certificate may show that a person was born in Texas, but how do you know it's the same person who is presenting to you as a new employee? Now, sometimes one document can do both things. For example, a passport can show that you're a U.S. citizen, and it obviously has a picture in it. So you just need one document if you're using a U.S. passport. But for example, if you're using a birth certificate, it's not going to have a picture. Or if it did have a picture, it's going to have a picture of a baby, right? So it's not very helpful. But if you had that birth certificate and then you had a driver's license with the same name, driver's license is going to have a picture. You can use that picture to make sure it's the same person who is actually working for you. And then looking at the name of the driver's license, you can connect that name to the birth certificate. So it is possible to do it with two documents or with one document. The I-9 process is potentially a very complicated process. I mean, your garden variety situation, most people bring in a social security card and a driver's license, or a passport, or a birth certificate and a driver's license, if the birth certificate is from the United States. Those are, probably the 90 to 95% scenarios. But for those 5 or less % of people who have unusual circumstances, they might present all kinds of other documents. I mean, there's literally hundreds of other documents that potentially can be shared. Many of these documents can be surprising in how they look, and can sometimes look honestly suspicious. They can look like, gosh, that's official. Doesn't really look official to me, even though it is completely legitimate. So as a result, it can be a very tricky law to enforce in those relatively few cases where people don't have the straightforward documentation. So something to keep in mind. So this is a helpful way of, again, more vocabulary terms. A legal alien is someone who has the legal right to work in the United States. Alien in this context doesn't mean ET, it means somebody who is a foreign national, whose citizenship is not U.S. An undocumented worker is somebody who's not authorized to work in the United States, or in many cases, not even eligible to be present physically in the United States. There's other terms for this that can be offensive. I'm not going to use them, so I'm going to use the term undocumented workers. You'll sometimes hear people refer to these individuals as workers without the correct papers. And that's kind of what they're getting at. A system that the government has put into effect is called E-Verify. It will, in the I-9 process, give an extra level of security here, because what happens is the information, the driver's license number, the passport number, whatever the documentation is, that is actually provided into this government database. And then the government will respond by saying whether these documents are legitimate or not, and whether this person is actually eligible to work in the United States. So it's yet another level of confirmation. The E-Verify is not perfect. It has its good aspects and it has its bad aspects. In some states and for some companies, they are required to use it. Others, it is an optional program. I can tell you one of my jobs when I was at JCPenney was to run the I-9 program. And so I handled many very, very sad stories. Or not handled, but I was involved in many very, very sad stories of individuals. So it was very common at times, I don't know if it's always this case, where you'll have individuals who are doing everything they can to get the documents that they're supposed to have, and yet the government may be slow about issuing the correct documents. No one other than the government is at fault for this. And yet when documents expire and they haven't, the employee hasn't been given the updated version, the employer has no choice but to end the employment relationship, even though the employee is not to blame at all for this. And I've had many, many very, very moving, sad stories about how that played out. I won't share them with you because you'll start crying, but doing I-9 work can be very difficult. I've also had situations where I can think of one where we had a very long-term employee, over 20 years, and a manager in that facility. A little bit of background. When I-9 rolled out, when IRCA became law, it wasn't retroactive. So anyone who was currently employed with your organization was not required to provide I-9 documentation. It was just any future hire. Now, IRCA has been around for so long that virtually every employee in America has done I-9 compliance, unless the company is just not complying with the law. But this was at a time period where you still had a kind of a mixed population. You had some folks that had been around before I-9 days and some that were obviously hired after. IRCA had probably been in effect for at least 10 years. Anyway, a particular manager thought, well, let's just go ahead and run everybody, because now we have half the people in one situation, half the people in the other situation. He wasn't supposed to do that. I don't think he had any evil intention. He himself was Hispanic, although he was native-born Hispanic, native-born to the United States Hispanic person. Anyway, it ended up that his second in command was here without correct documentation. And so she had to be dismissed. Obviously it was a very traumatic thing, and he deeply, deeply regretted rolling that program out. But once we found out that her documentation that she had provided was not lawful, we had no choice but to end the employment relationship. So lots of sad, sad stories out there. Okay, so moving from that to happier things, or I guess not happier things, but different things, we're going to talk about the topic of performance appraisals and the disciplinary process. So most employees are going to have an appraisal at the end of their probationary period, which is usually at 30 or 90 days, sometimes at the 6-month point. And then after that point, typically the employee is going to have an appraisal once a year. That's a pretty good system. That's what most employers do. Here we have a definition of performance appraisal. It's a periodic review of the employee's appraisal performance. Usually the immediate supervisor is the one who develops it and shares that with the employee, but oftentimes it's also reviewed at a higher level. It's also true that in many organizations, the employee comes up with kind of the first draft of the appraisal. After all, who knows better what the employee's been working on than the employee himself or herself? So many times that is kind of the first source of information. Obviously, if you are in a role like that, it makes sense to save data about your accomplishments throughout the year, and especially at the beginning of the year, things you might not remember at the end of the year, so that you can brag about yourself at the time that your performance appraisal comes due. So what are the purposes of a performance appraisal? It's probably pretty intuitive. You want to you want the employee to, if you're the employer, you want the employee to know what is valued in the organization. What things does the employer really, really want to focus on? Sometimes it's obvious. If I'm a salesperson, what the employer wants me to focus on is generating lots of dollars of sales. Pretty intuitive. But if I have a different type of job, it may not be immediately obvious what my primary goal might be. For example, being a teacher. What does Colin really care about? Does Colin want me to evaluate me based upon the number of A's I give? Well, if they want me to give lots of A's, maybe I'll start giving more A's. Or does it care about the number of students who enroll in my classes? Well, then maybe I want to make sure that I give lots of A's so that My rating on rate my professors especially high. You know, there can be lots of different ways to motivate employees and cause them to make various performance changes. Sometimes the performance changes may not be there may be unintended consequences for some of them though. So you have to think through, well now, if we tell the employee these are the factors we really care about, then what are employees likely to do to accomplish that? Let me give you an example. If I'm a commission salesperson and I'm told, oh, we're going to measure you on how many sales you get. Well, what might happen is I might try to persuade friends and family to buy things from me right before my appraisal time, but still within the window that they can return the item. So once my appraisal is over and I have these really high sales, then they return the items, 3 days later for a full refund. And in fact, they weren't real sales at all. So you have to keep in mind when you're the employer, are you incentivizing exactly the conduct that you want to incentivize? And obviously you also want to discourage certain behaviors. So you can have, things that might talk about diversity or inclusive awareness, if that is a value that your organization is trying to emphasize, for example. There is a lot of potential for discrimination in appraisals, obviously. For that reason, it's oftentimes helpful to use objective criteria in the appraisal. But objective criteria can only take you so far. I mean, you can't really have objective criteria, for example, for diversity awareness, just not numbers for that. Yes, if you're a salesperson, probably you're going to focus on numbers. But if your job is being a secretary, I'm not sure how many numbers there are going to be in that job. How many calls you answer that day, how many typos you had. I mean, who's going to be keeping track of that? It's likely to be a much more subjective type evaluation. And certainly, when you're dealing with supervisors and managers, many of the most important characteristics are going to be subjective. And, subjectivity opens up that door to some implicit bias. So as you're going through, if you're the manager and maybe you have several supervisors underneath you who are evaluating people, it's good to make sure that there's a process by which you're comparing people. So if, let's say you have 3 supervisors and each one of the supervisors has 20 direct reports. So you have a total of 60 people indirectly reporting to you. Well, if you see that Supervisor A gives significantly lower appraisal ratings than Supervisor B and C, then you might want to go in and kind of see what's going on there. Maybe Supervisor A just happens to have bad luck with the quality of his or her subordinates, or maybe that person's a tougher grader. If a lower appraisal means that those individuals are less likely to be promoted, or less likely to get a raise, or more likely to be riffed or laid off in a business downturn, then those differences are significant. You'd also want to see, well, over my 60 workers, does there seem to be some statistical reason to think that African Americans or women or other groups are more subject to bad appraisals than other groups, and to see if there's some kind of statistical evidence for that. See if there's anything else. So Bob is an Asian male. He received his first performance appraisal by his new supervisor. And this is what the supervisor said. Compared to the other project managers, Bob falls below expectations in the performance of his job duties. He has missed 4 out of 6 deadlines in the past year without justification. Bob's needs to improve his time management skills. Assuming these statements are correct, there's no liability. This is a very objective standard. And so under those circumstances, Bob would not likely have a strong case for a national origin discrimination or gender discrimination. Sometimes, in addition to the appraisal process, it becomes necessary for an employer to engage in disciplinary action. And so the question can be, well, why would you engage in disciplinary actions if everybody is employed at will? If somebody's doing something you don't like, why don't you just fire them? Well, of course, one reason is, I mean, almost no employee is always going to do everything that you like. I mean, you know, nobody's perfect. And so, you know, there's going to be problems from time to time. So identifying a problem and saying you need to fix it doesn't necessarily mean that person is not a valued employee. But another part of the reason that you want to give people the opportunities to change behavior is that the expectation that juries almost often have is that even though we are in an at-will employment environment, the idea is, well, that really a just cause standard ought to be the one that is really used in the workplace. And so most employers, at least the larger employers, typically use a just cause discriminatory, disciplinary approach. But they don't use this when it's necessary to do a business layoff because of economic hard times, but when they're dismissing somebody or disciplining somebody because of poor work performance, they typically view it as if their just cause standard applied. So when we talk about just cause, what are we talking about? And you might want to add this to, I know I didn't put this in red, but you might want to add this to your Quizlet. This is a good one. So what are the characteristics of a just cause system? Well, first of all, it's going to have due process. The employee is going to have an opportunity to respond. Oh, I think your attendance records about me are wrong. You show here that I was late on June 14th. I was on vacation that week, so I couldn't have been late. You show that I wasn't very productive on that date, but I wasn't at work on that date. So due process allows the employee to respond by either explaining whatever the issue is or refuting that information. It also requires that there be adequate evidence. It's not just a subjective opinion. Bob, you're a lousy worker. Well, what does that mean? Give me some specifics. Well, Bob, you missed these 4 deadlines. You were supposed to complete that report by Sunday, and it wasn't completed until Wednesday. Then, you know, okay, so now you're giving me specifics. You need to have the details. And there also needs to be a reasonableness about the penalty. You don't fire somebody who's 5 minutes late one time. You probably don't do anything for being late one time for 5 minutes. But maybe on the third tardy, you sit down and give that person a verbal warning. And then maybe on the 6th tardy, you give that person a written warning. And then on the 9th tardy, you give that person a final warning. And then maybe on the 10th tardy, that's when maybe you dismiss the person. You give that person lots of opportunities. And of course, that's progressive discipline when you don't dismiss on the first offense. So progressive discipline, again, another Quizlet term, is the series of steps taken before an employee will be terminated for poor performance. Most misconduct is going to be subject to progressive discipline, but there will be categories that you don't do progressive discipline for. For example, employee theft. You're not going to do progressive discipline for that. Violence. Somebody who has hit a worker or a customer or something like that, you're not going to give that person progressive discipline. Somebody who comes to work intoxicated, you're not going to give progressive discipline, probably under those circumstances. But most of the time, especially for tardies and lates and low productivity, you're going to give some type of progressive discipline. But let's say you've used the progressive discipline system and now it's time to terminate. This person is not able or not willing to make the performance changes. Well, obviously termination is a big deal. Termination is by far the single most risky employment decision an employer makes. We've talked about lots of employment decisions, but the reality is most of the time when an employer decides not to hire somebody, it doesn't result in a charge of discrimination. That's pretty rare because after all, if you are applying for jobs, you're probably applying in lots of different places. You aren't sufficiently focused on one particular place. Plus, you don't even know who was hired or why that person was hired. So you, the candidate, really don't have enough information to know if you were subject to discrimination or not. As a result, in most cases, if it's a failure to hire situation, it's not going to result in a lawsuit. Most of the time when somebody's demoted or promoted, they're still working in the organization. And the idea of filing a lawsuit against your current employer, most employees are going to pass on. That's too stressful. But when a person is terminated, there's really no reason not to. I mean, they're not going to be working in that former place of employment, and so they see it as a safer situation. I mean, most terminations don't result in a lawsuit, but by far, that is the most likely time to have a lawsuit. So when a client wants to terminate somebody, many times it will go to its legal department for approval or perhaps to outside counsel for approval. And this is the opportunity before the termination happens for legal counsel to support the company in making sure that decision is a wise one for the company to make, and also making sure that if it is the wise decision, it is executed in the way that is most likely to put that company in the best legal posture as possible. And obviously this is going to involve documenting the situation carefully and accurately and considering as many different perspectives as possible. Whatever the reason for the termination, it's really important that the employer treat that employee with courtesy, respect, and also with privacy. There's really no upside in embarrassing the employee when you're deciding you're going to dismiss. You're trying to end the employment relationship. You're trying to diffuse the situation. It is to your benefit to allow that employee to leave with as much grace as possible. And so that is an important factor. I've seen cases in which an employer had a really strong case to dismiss the employee, but because how he or she handled the dismissal, that is what gave the employee a pretty decent claim. And in some cases resulted in a significant recovery for the employee. So you not only have to be careful that you're terminating in the right circumstance, and you're doing it in you've developed the case in the right situation, but you also execute the decision in an appropriate manner. So at this time, we have completed this. We've talked about the recruitment of appropriate candidates. We've talked about pre-employment testing and occasionally post-employment testing. We've talked about how to make the decision to hire and how to implement it. We briefly discussed the idea of performance appraisals and discipline to current employees. And again, we very briefly talked about the topic of termination. Some things to think about going forward is you need to advise your clients to document. If it's not written down in some or typed or stored in some kind of database somewhere, it's like it never even happened. Supervisors and managers need to be trained about how to conduct evaluations and hiring, removing as much bias as we possibly can as human beings. We have to be careful to keep information confidential, and we have to make sure that we have a system to evaluate performance that is fair, that is non-discriminatory, that is systematic, and also that is frequent, that is done on a very periodic, consistent basis. Hope that this presentation, or all these presentations, have been helpful for you. I thank you for your attention. As always, if you have questions, please pop into my office hours so we can chat in more detail. Thanks for your attention. Have a wonderful day.